Good Friday Agreement brought peace to Ireland, and the Patton Report ended the murky days of covert policing that targeted countless Irish Republicans. However, on the 9th of March 2009, the first ever PSNI constable is shot dead in Craigavon. Brendan McConville and John Paul Wooten are immediately arrested, imprisoned without trial until 2012, and remain inside until today. They are known as the Craigavon 2. Questionable evidence and covert tactics played a major part in their conviction, and it bears the hallmarks of a miscarriage of justice. This documentary looks at the evidence used to convict the Craigavon 2 against the hope promised by the Good Friday Agreement and Patton, and asks, was justice done in Craigavon? The Craigavon 2 Justice Campaign team, once chaired by Jerry Conlon of the Guildford Four, protest their innocence. Campaign chair Joanne Donnelly believes there is something sinister behind their conviction.
We're campaigning for the immediate release of Brendan McConville and John Paul Wooten. Both these two lads were sentenced to life in prison in a Diplock court, so they were denied the right of a fair trial. We're here today marching with our comrades in JENGBA, Joint Enterprise Not Guilty by Association, to help put pressure onto the British government in terms of reviewing cases of joint enterprise. Both Brendan and John Paul were convicted under joint enterprise legislation. We and the committee and the campaign believe that the evidence against John Paul and Brendan was manufactured to cover up for state agents.
Brendan McConville is represented by Darrell Mackin of KRW Law, and John Paul Wooten is represented by John Finucane of Finucane and Toner Solicitors.
The case is entirely circumstantial evidence. What we would say is that there's no direct evidence that would incriminate Brendan McConville, whom we represent.
I would have no hesitation at all in describing the conviction of my client John Paul Wooten as a miscarriage of justice.
Crucial to McConville's conviction is witness M. However, M did not come forward until 11 months after the shooting, and did so in a drunken state. M's relative, known as witness Z, discredits his evidence at the appeal in October 2013, and in an affidavit he called M a compulsive liar, a Walter Mitty character with a fertile imagination. He also questions M's eyesight.
He effectively said that on the night in question he left his house with his partner, his dog, and he was pushing a pram. He went for a walk to a relative's house. On the way to the relative's house, he seen an individual who he knew as Brendan McConville. Our defence, and Brendan McConville's defence always was and remains the fact that he didn't actually know witness M. More than that he was not there that night. He never said hello to witness M, and that is entirely baseless and untrue. Like, common sense would say that somebody who's out to commit murder will not be lurking about street corners openly waving and saying hello to people. The distance witness M described as he was walking down the opposite side of the road was quite some distance from where he said Brendan McConville was standing. At that time, we came in contact with a relative of witness M, and who told us that he wore glasses. At that stage, we put forward to witness M in evidence whether or not he wore glasses. He said he didn't wear glasses. Again, we asked him whether or not he could see from the distance, and he said he could see from the distance. What then came forward, and has transpired, when we adduced the evidence that we had come into possession of, which was witness M's effectively prescription for his glasses, witness M relented on the original statement that he had said, and said he wore glasses simply for fashion purposes. However, that was completely contrary to what the prescription was for. The prescription was for obviously a defect in eyesight. It was then further concluded when we looked at various experts who examined the evidence, that it became clear that there were issues in respect of whether witness M could in fact see from the distance he purported to see from. So at the very offset, it was already a concern as to whether witness M was telling the truth, because it would appear that from the eyesight condition he had, that he would have struggled to see anybody, regardless of who it was at the other side of the road from that distance. And secondly, big belief as to why witness M would give evidence to say he didn't wear glasses when he knew fine well that he did wear glasses.
Wooten's legal team then discovered that witness Z had been arrested and harassed by the PSNI in what they claim was an attempt to undermine the appeal hearing of the Craigavon 2.
When we entered the bar, witness said was there, and we basically asked him where he'd been, why we couldn't get contact with him, and he said that he'd been arrested and he'd been held for 4 days in a police station. This is a man who's over 70 years of age, had never been arrested before in his life, who was obviously completely traumatised by the incident, and in particular the lead up to the incident, in which he said that the police had called a number of times.
McConville's parents and fiancée tried to cope with uncertainty on the outside.
After having a stroke, it made him think about his health. So he started speaking to the doctor and losing weight.
And Brendan had a stroke in prison.
Yes.
Yeah.
They didn't even tell us at the time.
His parents weren't informed.
We weren't informed. It was one of the
Prisoners.
rang us and told us. And then I got on to the governor,
Yeah.
and there's someone in there, and they got the governor to ring me back, and he says it wasn't serious, you know. I said, are you a doctor?
What do they class as
You know.
serious?
I said, are you a doctor? Do you know what's wrong with him?
Yeah.
He says, no. And then he was sent to the hospital then.
Was that outside hospital?
That's
Yeah,
Legan Valley.
Legan Valley in Lisburn.
How long was he in there for?
He was in there for about
Some
3
2
or
or
4
3
days.
days before we knew that he was in.
He was in
We
there.
didn't get to see him in the hospital.
No, you couldn't. And they had him handcuffed to the bed when he was there. And they
And the policeman,
they said we wanted him
two of
off.
them inside,
Sat-
beside the
sitting
bed, sitting with him. And
And they said,
One at
he
the
said he
door.
wanted him off. And they wouldn't take him off. And he said to the doctor, I want to send myself out back to the jail. And then they took him off.
It's terrible.
Why didn't they tell you? Did they give any reason for not telling you?
They just don't care.
didn't think it was serious.
It's just,
And that what they said.
that didn't think it
Didn't
was
think it was
serious.
serious.
These are all the court files. Those are all his court files.
Information collected by a questionable tracking device placed in Wooten's car by a covert British Army unit proved detrimental to his defence.
What is of concern to the defence is that neither defence team had the opportunity or the ability to investigate or interrogate that device. We have to take the prosecution, or certainly we have to take the Army's word that was a device placed externally on the car and not internally, and that essentially it was a glorified GPS tracking device. We would have concerns that it had the ability to pick up audio and potentially visual data as well, but we have never had that confirmed to us. If audio was on the device, which I think common sense would dictate that most devices would have that capability, then I think it would go a long way to proving the innocence of my client. But yes, there was a tracker on the car. Certainly the initial data that comes from that, I think, would be in Mr. Wooten's favour, and the reason for that is that it would show that the car owned by John Paul Wooten wasn't moved until 10 minutes after the shooting, but inexplicably data from that device was wiped, and it was wiped in a very deliberate fashion, which was accepted by the British Army personnel at trial, and we think serious questions remain about the integrity and the weight given to that evidence.
The principle of joint enterprise was also employed in this case. So what is it, and what effect did it have on Wooten?
Joint enterprise is a legal concept in which you don't necessarily have to carry out the act yourself to be guilty of it. For example, if I am a getaway driver, I would be as equally guilty of a murder if I am ferrying a gunman to carry out a murder and then ferrying him away from that. I'm clearly aware that the person in the passenger seat with the gun is there to kill somebody. There is a joint enterprise, there is a joint goal to carry out a crime. But what that requires is clear evidence that there was that agreement. There is no evidence that has ever been put before the court which would show that there was an agreement between John Paul Wooten and the killers. Now, in that at both the trial and subsequently at the Court of Appeal, no role has ever been ascribed to John Paul Wooten. So we are faced with a situation where somebody who was a child in the eyes of the law at the time of this offence finds himself in Maghaberry since 2009, guilty of the murder of a police officer, and nobody within the police or within the prosecution or from the courts can tell him what exactly he is guilty of. What they can be clear about is what he didn't do, and they are clear that he was not the person who was at the firing point or pulled the trigger, which killed Constable Carroll, but that he played some sort of supportive role either before or after. What that role is, the courts do not know. The prosecution have never submitted what that role is, but John Paul Wooten finds himself in jail.
So how can a government, in an era of peace and power sharing, allow covert tactics to be used in evidence in a court?
That when we ask for access to, for example, surveillance logs, to the devices, to for example, the logs underpinning the deployment of the various devices, the tracking device on the car, we were met with a steel wall of national security in the sense that it cannot be disclosed because it undermines, our counter-terrorism abilities. The reality is that then hampers somebody's ability to get a fair trial.
And if you look up on the MI5 website, it actually says that. It says something along the lines of successive governments have decided not to define national security in order to give it sufficient flexibility to adapt to changing circumstances. But we've repeatedly asked the question of government in relation to what that means in the context of MI5's activities and the primacy for covert national security policing, and we've been told what it means as Republicans.
Wooten's family talk about how it has affected them and his mood on the inside.
2 months off his 18th birthday when he was arrested in front of my eyes, so it was heartbreaking to see, my eldest son being arrested for something he didn't do. Sad to see that even going up on the visits, I hate leaving him there, just wanted to bring him home with me.
Is he hopeful of another appeal coming?
Well, he is, but the last appeal, he sort of had his hopes built, and with the whole witness thing and the way it went, and the three judges just didn't want to listen, it sort of knocked him down a bit. So he's hopeful, but he doesn't want to get too hopeful,
So what has significantly changed since Patton and the Good Friday Agreement?
Since the Good Friday Agreement and the Patton Report, it is the case that policing accountability has drastically improved overall, in the sense that we now have some of the most powerful policing accountabilities bodies in the world. But there is a very significant gap in a number of areas, and the primary area is the area of covert policing, the whole area of informant handling, surveillance, interception of communications, where there are very significant accountability gaps, partly because things under the Patton settlement weren't implemented, but also partly because huge areas of that most controversial and most concerning in human rights terms areas of policing have been placed outside the police and vested in the MI5.
While the immediate future may not look bright for the Craigavon 2, some hope does lie with the CCRC.
The CCRC, or the Criminal Cases Review Commission, they are an exceptionally powerful body. They have investigatory powers. They will be able to look at material that the defence would not have the ability to look at, and ultimately they would have the ability to declare a conviction unsafe or certainly send the case back for a retrial. And an application has been sent to the CCRC. They are inundated with applications on a yearly basis. Their resources are very much stretched. So they will look at that. They will have the ability to find out information regarding the tracker. If they are resisted on that, then I think they will come to hopefully a firm conclusion as to why they are being resisted on that. They are not a toothless tiger. They do have these powers, and we hope that they exercise them fully.
While there is hope in the CCRC, this process can take months, and the Craigavon 2 are approaching their 8th year inside. However, Wooten and McConville's innocence is not the only thing at stake here. What is at stake is a justice system that was supposed to have so radically changed. A cloud now hangs over that system. Those who believe in the equality of the system need to act, and need to ensure that for Wooten, for McConville, and for Constable Stephen Carroll, that justice is done in Craigavon.
The battle will be over. For that day when we shall lay down our burden and study war.